Hi, and welcome to the Deep Dive, your shortcut to getting informed. Today, we're digging into an article with a really, a surprising take on Ukraine's anti-corruption setup.
Yeah.
It's not just saying the reforms failed. No, the author suggests something much more intricate is going on.
That's right. The author we're talking about is Vyacheslav Vasilievich Morgun. He's got a PhD in law, specializing in municipal law and economics, so he's looking at this through a very specific legal lens.
Okay, so what's the big idea? Morgan's central thesis is, frankly, quite shocking when you first hear it. He argues that the whole anti-corruption system in Ukraine, NBU, SAPO, HACC, it isn't just ineffective. He's actually claiming it's a carefully designed legal operation.
Yeah.
And his goal, not fighting corruption, but legalizing assets for top corrupt officials.
And crucially, he points out this entire apparatus is funded by Ukrainian taxpayers. It's a powerful claim.
It really is.
Yeah.
So let's break down how he argues this works. He lays out this mechanism.
He calls it the anti-corruption trap. It's laid out in 5 steps, starting with some fundamental legal issues, according to him.
It's exactly. Step 1, creating bodies that are, in his view, unconstitutional. Take NBU, the National Anti-Corruption Bureau. The author argues its establishment violated the Constitution, Articles 19, 6, 1, 13, basically because it's an executive body, but doesn't report to the Cabinet of Ministers.
And he backs this up, right? He points to that 2020 Constitutional Court ruling.
He does. The ruling declared the NBU director's appointment unconstitutional. For Morgan, this confirms NBU's questionable legal standing right from the start. Then there's HACC, the High Anti-Corruption Court. Created by law, yes, but he questions its constitutionality too.
Why HACC?
Because of the significant role foreign experts played in setting it up. The argument is this might clash with Article 5 of the Constitution, which is about national sovereignty.
Okay, so if the bodies themselves have these alleged legal vulnerabilities, what about the work they do, like collecting evidence?
Well, that leads straight into step 2, producing what the author calls poisoned evidence. Because NBU's status is allegedly unconstitutional, the argument goes any evidence it gathers is tainted. It falls under the fruit of the poisonous tree doctrine.
Meaning it shouldn't be allowed in court? Inadmissible?
Precisely. And the article mentions big cases, like the private bank Kolomoisky case or the Martynenko-Voskesky case. The defense in these cases could potentially use this argument to just nullify the evidence. Years of work potentially down the drain.
So compromised evidence. How does the author say convictions even happen then? Because they do initially.
Good question. That takes us to step 3, distorting the role of prosecutors, specifically regarding SPO and also the NAACP, the National Agency on Corruption Prevention. The claim here is that the anti-corruption laws improperly gave prosecutorial powers to bodies like NAACP.
Which violates the Constitution.
Yes, Article 131.1 apparently gives the prosecutor's office a monopoly on prosecution. So delegating this power elsewhere breaks that and also undermines legal certainty, the idea that law should be clear. It's like messy legal boundaries.
I see. So shaky foundations, poisoned evidence, blurred prosecutorial lines, and then step 4.
Step 4 is the conviction in a national court. The author describes this rather cynically. Conviction amid the approving applause of the public. Almost like theater.
A public win, but maybe not legally sound underneath.
That seems to be the implication. But then comes the really clever part, according to this article. Step 5. This is the appeal to the European Court of Human Rights, the ECHR, leading to the verdict being overturned.
How does that work?
The convicted officials appeal, arguing their right to a tribunal established by law. Article 6 of the ECHR was violated because, the bodies involved, like NEU or HACC, have these alleged constitutional issues we discussed. They'd rely on ECHR precedents, cases like Sokorenko and Strigon v. Ukraine.
And if the ECHR agrees?
If the ECHR rules in their favor, the national verdict gets annulled, charges dropped, and crucially, any legal basis for seizing their assets just disappears.
Wow. So the final outcome, in this view, is freedom for the official.
Freedom, yes, and even more than that, according to Morgan. It's the legalization of the assets they allegedly looted. The ECHR decision basically acts like a certificate of cleanliness for that money.
So the person walks free and there's suddenly a law-abiding businessman with legal capital. That's quite the turnaround.
And all funded, the author stresses, by the very taxpayers who were initially harmed. It's a deeply cynical picture he paints.
The article also touches on other elements, doesn't it? Like public perception.
It does. It talks about manipulating students and activists using their genuine desire to fight corruption as a kind of smokescreen.
Yeah.
Creating this appearance of public support for systems that, he argues, are actually designed to let the big fish off the hook. He points the finger at transnational finance, oligarchs, and corrupt elites as the real players.
He also mentions different types of laws that enable this.
Yeah, briefly. He categorizes them. Laws for plundering wealth, land, resources, laws creating repressive systems outside public control, and laws that rig the electoral system to keep corrupt power in place.
And this isn't just one author's outlier view. He mentions others.
He references warnings from constitutional scholars about creating institutions in a legal gray zone. The argument about NABU needing independence is framed as misleading. True independence, the counterargument goes, comes from the rule of law, from being within the constitutional framework, not outside it. Examples from Romania and Poland are mentioned as cautionary tales.
So, given this stark analysis, what's the proposed solution? How does Ukraine get out of this alleged trap?
The author suggests concrete steps. First, change the laws to make NABU and SAPO status clearly constitutional. Second, overhaul how judges are appointed to remove outside influence, make it truly sovereign. And third, conduct an independent audit of all these anti-corruption bodies, focusing on whether they respect citizens' constitutional rights.
It sounds like a call for a fundamental reset, focusing on legality.
Absolutely. It's a call, as the author puts it, for genuine justice and lawful procedures, not just the appearance of fighting corruption. It's about getting the foundations right.
Which leaves us all with a pretty challenging thought, doesn't it? What does it mean if the very tools you create to fight corruption could potentially end up legitimizing it? Something to really think about.